So here with Kevin Werbach, a professor at the Wharton School at Penn, who just testified a bit before the House on Electronic Communications Privacy Act reform. Good afternoon, Professor.
Hi.
So you talked a bit about the importance of getting this right for the Internet economy. What is there about getting privacy protections regarding electronic communications correct with regards to economics?
Well, it has to do with economics, it has to do with civil rights, it has to do with law enforcement, and it has to do with the evolution of technology. The point that I was making today at the hearing was that we talk about things like cloud computing and the internet as though they are new technologies and new services. We think about a few examples like web-based email. But in fact, the cloud is really all around us. And increasingly, internet access is pervasive. It's not just to PCs, it's to multiple devices. More and more data resides on servers in the network and uses cloud-based technologies to access and store and synchronize it. So if this is the way the world is going, if more and more data is spread across the network on these massive data centers, we need to understand what the rules are for access to that data. And the main law called the Electronic Communications Privacy Act that governs when law enforcement get access to that data on computer networks is 25 years old, and that needs to be updated.
So what specific elements of it need updating the most?
The law, remember in 1986 when this law was passed, the internet was not even a commercial network the way it is today. And so the law makes a sharp distinction between what are called electronic and stored communication services. It has a whole set of different tests, different requirements for when police have to get a warrant and a subpoena and so forth. And it's all based on very outdated assumptions about the way technology works. It doesn't recognize that today data being stored in the cloud is a commonplace. It's not a rare exception.
What are the risks to the internet economy and commerce in this country if the law isn't updated?
Well, there are certainly lots of risks in terms of the fallout for providers and so forth, but the real question is one of trust. People need to trust that when they put their data on web-based services and in the cloud, that it's going to be protected. And that's incumbent upon service providers to provide protections for users' data. But it's also important that people feel comfortable that if law enforcement gets access to that data, it's based on a fair, legitimate, transparent process. So if we lose trust that our data is protected, that will cause people not to put data in the cloud or to make other sorts of decisions that will just add friction to the internet economy.
There's a concept called intermediary liability that's come up specifically in the context of other countries. What are the risks to the providers themselves if that becomes enshrined in our own trade laws?
Well, intermediary liability has to do with whether the intermediary, the service provider, is held liable for generally the actions of its users. So this has come up a lot, for example, in copyright law, where the question is whether, say, peer-to-peer file sharing services or a service like YouTube is liable if one of its customers uploads some infringing material. And that's actually the subject of this big lawsuit that Viacom filed against YouTube, as well as many other cases. It's a broader issue, though. As more and more services have these intermediaries holding data, the intermediary needs to have some confidence that it's protected against what its users do, and the users need to have some confidence that their data is protected. And similarly, governments and law enforcement need to have some confidence that if they have a legitimate reason to get information, law enforcement needs to get certain information because they're trying to stop crimes, that they can do it subject to a fair and transparent process. So if we go too far and make the intermediaries liable, they'll shut down, they'll put other restrictions on what their users do, it'll lead to less efficiency, and may ultimately lead to less protection for users' data.
So are there risks to the country's competitive climate if this does not go forward in the near future?
Well, there's no question. Cloud computing is a force that's happening all over the world. Many countries and companies abroad are investing heavily in this technology as well, and it's a global internet. So individuals and companies will put their data where it's cheapest and where they feel like there are the best procedures and protections for their data. So there's no guarantee that the U.S. will continue to have a leadership role in the internet economy unless we continue to ensure that our legal system is up to date.
As you talk to business leaders and people in Congress and in the academic community, what are the prospects for this moving forward within the next year?
I wouldn't feel confident handicapping it, but the fact that this committee, the House Judiciary Committee, is having a series of hearings. The Senate held some hearings yesterday, and there's a widespread support from a coalition of interest groups and companies and service providers to reform the law. It certainly does seem like there's some possibility that things will move forward. It's ultimately really not a partisan issue, but it's as with anything else before the Congress, they need to understand that this is not an arcane issue. It's one that affects people's livelihood and affects the competitiveness of the country.
Well, thank you for your time, Professor.
Thank you.